If it pleases the court, my name is Freeman initial M and I appear with my learned junior counsel Wilkie initial D for the defendant True Tone Grill. Your Honour, in order to consider an action in tort law, there needs to be an evident existence of a duty of care, a resulting breach of that duty, and ultimately a reasonably foreseeable damage as a consequence of the breach of duty. Your Honour, the defendant presents four main submissions in order to rebut the allegations put forth by counsel for the plaintiff. These submissions are listed respectively as 1, 2, 3, and 4. I will be presenting the first two of these submissions, being submissions 1 and 2. My learned junior counsel will then present the remaining two submissions, representing submissions 3 and 4. For submission 1, counsel for the defendant acknowledged the defendant as the occupier of the premises owes a duty of care to the plaintiff as a patron. Although counsel for the defendant acknowledged a duty of care is owed, counsel also argued this duty has been fulfilled by the defendant. It is our submission, as per Section 9(1) of the Civil Liability Act 2003, that a person does not breach a duty to take precautions against a risk of harm unless the risk was foreseeable, the risk was not insignificant, and, in the circumstances, a reasonable person in the position of the defendant would have taken the precautions. In the High Court decision of Adil's Palace Pty Limited and Mobarak reported in 2009, volume 239 of the Commonwealth Law Reports, page 420, the High Court considered a duty of care distinguishing Modbury Triangle Shopping Centre Pty Limited and Ansell, reported in 2000, volume 205 of the Commonwealth Law Reports, page 254, on duty arguments involving third-party conduct. The court unanimously concluded that even if there was a negligence finding, this carelessness was not the cause of the plaintiff's injuries. The High Court noted in Adil's Palace that there was no evidence to indicate the third party would have exercised rational judgment. Counsel for the defendant argued that any further conduct undertaken by the defendant may have been able to deter or prevent the third party from injuring the plaintiff. However, considering the facts in their entirety, there is no evidence in the present case to conclude this would have had this effect. Counsel for the defendant referred to the court's statement in Adil's Palace, whereby the court stated, "As in Modbury, the event which caused the plaintiff's injuries was deliberate criminal wrongdoing. That being so, it should not be accepted that negligence, which was not a necessary condition of the injury that resulted from a third person's criminal wrongdoing, was a cause of that injury." Accordingly, the submission that the plaintiff's injuries were caused by the failure of Adil's Palace to take steps that might have made their occurrence less likely should be rejected. Based on this judgment, counsel for the defendant requests the same decision be applied. For submission 2, counsel for the defendant submit the defendant did not breach their duty of care. One of the main elements of the tort of negligence involves assessing the standard of care and whether or not there has been a factual breach of the duty to take care. The duty of care owed by the defendant is general in nature. Although counsel for the defendant have acknowledged a duty of care is owed, counsel also strongly argue that owing an individual a duty of care is not sufficient in establishing liability. Liability only attaches to the breach of duty when it causes harm that is not too remote. At common law, the standard of care in any given situation is governed by Justice Mason's decision in the leading High Court of Australia case, Wyongshire Council and Shirt, reported in 1980, volume 146 of the Commonwealth Law Reports, page 40. The case of Wyongshire Council and Shirt established that the first matter that must be established is that the risk of injury was foreseeable to the reasonable person. If this element is sufficiently satisfied, the court must consider a so-called negligence calculus. Your Honour, this means the court must, under the circumstances, consider all of the relevant factors which would influence any reasonable person in determining whether or not to take specific precautions in order to ultimately avoid the risk of injury or harm manifesting itself. With reliance on this case, as well as Section 9(2) of the Civil Liability Act 2003, counsel for the defendant requests the court consider the probability of this particular risk materialising and the gravity of the risk occurring compared to and balanced against the practicability of precautions necessary to reasonably guard against the foreseeable risk and the social utility of the defendant's conduct. This balancing act underlies the approach stated by Justice Mason in Wyongshire Council and Shirt, whereby it needs to be implicitly asserted that the foreseeable risk itself is one that is not far-fetched or fanciful, and there needs to be a consideration of the magnitude of the risk and degree of probability of its occurrence. As such, counsel for the defendant requests the court objectively imply and ascertain whether a relevant established category of duty of care exists under the given circumstances. Counsel for the defendant requests the same notion be considered as relied upon in Australian Safeway Stores Pty Limited and Zaluzna, reported in 1987, volume 162 of the Commonwealth Law Reports, page 479, which required the application of rigidly defined and varying standards of care to particular kinds of occupier-entrant relationships. As such, reasonableness needs to be the governing criteria. This reasonableness criterion is furthermore supported by the High Court of Australia decision in Neindorf and Junkovich, reported in 2005, volume 222 of the Australian Law Reports, page 631. The decision formed in this case also highlighted and emphasised that practical realities must be considered when assessing reasonableness, and in a 6-1 decision, the High Court held that, as a question of fact, doing nothing was a reasonable response. It is our submission that the defendant is in no way responsible for creating the risk of injury and damage caused to the plaintiff. The standard of care expected of the defendant is objective. The defendant owed and fulfilled a duty of care to the plaintiff as a patron. The injury and damage sustained by the plaintiff should be categorised as far-fetched or fanciful and not foreseeable to the defendant. As such, it is clear, based on the facts of this case, that the defendant has acted appropriately, as per any normal, reasonably prudent person would have acted under the given circumstances. Your Honour, this concludes submissions 1 and 2. I will now hand over to my learned junior counsel, who will present and submit both submissions 3 and 4 on behalf of the defendant.